court case decision by Justice Belobaba, dated September 10th, 2018. The file number is C as in cat, V as in victory, -18-603797. It includes additional files CV-18602494 and CV-18-603633. And so the citation is City of Toronto et al. Versus Ontario, the Attorney General, 2018 ONSC 5151. The action is the City of Toronto as an applicant and the Attorney General, and also between Rocco Achapang and the Ontario government, which is the Honourable Doug Ford, Premier of Ontario, and the Attorney General and City Toronto. It's also between Chris Moyes, Ish Aderonmu, my apologies, so Aderonmu, and Prabha Kholsa, Khosla. Just so you're knowing, Achapang is Acham, as in Mary, P as in Paul, O, N as in Nancy, G as in Gary. And when I was speaking earlier, it's also on behalf of all members of Women Win TO, and it goes on to say interveners in addition to that. So, Justice Belobaba, just so you have it, is B as in Bob, E, L, O, B as in Bob, A, B as in Bob, A. It was heard on August 31st, 2018. And I'm just going to read down to the decision, the reasons for the decision, starting at page 3. This is Justice Belobaba writing. At line 1, these applications brought on an urgent basis challenge the constitutional validity of Bill 5, also known as the Better Local Government Act, 2018. For ease of reference, I will refer to the impungned provincial enactment as Bill 5, and I will refer to the provisions that are being challenged, that is, the provisions that change the number of wards and councillors from 47 to 25, as the impungned provisions. 2. Given the pressing need for a timely decision, I will forego a detailed analysis of every legal issue raised in this proceeding or the case law that pertains to these issues. I will focus primarily on the issues and authorities that, in my view, are the most determinative. Heading, the unprecedented nature of the case before me. Point 3. The matter before me is unprecedented. The provincial legislature enacted Bill 5, radically redrawing the City of Toronto's electoral districts in the middle of the city's election. Point 4. The election period for Toronto City Council began on May 1st, 2018, and was based on a 47-ward structure. Election day is October 22nd, 2018. At the end of July, shortly after taking power, the newly elected Ontario government announced that it would enact legislation directed primarily at the City of Toronto, reducing the number of city wards and councillors from 47 to 25, and de facto doubling the ward populations from an average of 61,000 to 111,000. Point 5. Bill 5 received first reading on July 30th, second reading on August 2nd, 7th, and 8th, and royal assent on August 14th, 2018. Bill 5 took immediate effect in the middle of August, in which point some 509 candidates for the October 22nd election had been certified. The candidates were in the midst of their campaigns, and the city clerk's preparations for a 47-ward election were well underway. Point 6. The enactment of provincial legislation radically changing the number and size of a city's electoral districts in the middle of a city's election is without parallel in Canadian history. Here is how the City of Toronto put it in the opening line of its factum. Never before has a Canadian government meddled with democracy like the province of Ontario did when, without notice, it fundamentally altered the City of Toronto's governance structure in the middle of the city's election. Point 7, page 4. Most people would agree that changing the rules in the middle of the game is profoundly unfair. The question for the court, however, is not whether Bill 5 is unfair. The question is whether the enactment of Bill 5 is unconstitutional. Heading, Decision. Point 8. I am acutely aware of the appropriate role of the court in reviewing duly enacted federal or provincial legislation and the importance of judges exercising judicial deference and restraint. It is only when a democratically elected government has clearly crossed the line that, quote, judicial umpire, quote, should intervene. Point 9. The province has clearly crossed the line. Point 10. For the reasons set out below, I find that the impunged provisions of Bill 5 substantially interfered with both the candidates and the voters' right to freedom of expression as guaranteed under Section 2B of the Canadian Charter of Rights and Freedoms. I further find on the evidence before me that these breaches cannot be saved or justified under Section 1. Point 11. The impunged provisions are unconstitutional and are set aside under Section 52 of the Constitution Act, 1982. The October 22nd election shall proceed as scheduled, but on the basis of 47 wards, not 25. If the province wishes to enact another Bill 5 type law at some future date to affect future city elections, it may certainly attempt to do so. As things now stand, and until a constitutionally valid provincial law says otherwise, the city has 47 wards. Heading, Arguments other than Section 2B of the Charter. Point 12. The applicants and interveners advanced a number of charter and non-charter arguments in addition to Section 2B, namely that the impunged provisions breached association and equality rights under Sections 2D and 15.1 of the Charter, and the unwritten constitutional principles of the rule of law and democracy. There's a reference. I make no ruling in relation to the provisions in Bill 5 that changed the selection process for the regional chairs in York, Peel, Niagara, and Muskoka from election to appointment. I recognize that Mr. Achapong included a challenge to these provisions in his application and filed a supporting affidavit from the campaign manager of a candidate in York Region. However, the Achapong application asked that Bill 5 be stayed, a remedy that was not requested by any other applicant and is not granted here because it requires a very different legal analysis. See Manitoba Attorney General versus Metropolitan Stores Limited, 1987. 1 SCR 110. A more complete legal and evidentiary basis would be needed before this court could comfortably consider a challenge to the provisions in Bill 5 that deal with the appointment of the 4 regional chairs. Page 5, point 13. I am inclined to agree with the province that none of these additional submissions can prevail on the facts herein. However, I make no actual finding in this regard. The Sections 2D and 15.1 submissions, together with the rule of law and democracy submissions, may live another day, perhaps to be litigated in another court. It is sufficient for my decision today to focus only on Section 2B of the Charter and the guarantee of freedom of expression. Heading, Analysis. Point 14. Several preliminary points should be made clear before I explain why the impunged provisions infringe Section 2B of the Charter. Point 15. First, there is no dispute that the province has plenary authority under Section 92(8) of, so that's 92(8) of the Constitution Act 1867 to pass laws in relation to municipal institutions in the province. Those are in quotes. Assuming the law falls under Section 92(8), close bracket, or indeed any other provincial head of power, the province can pass a law that is wrong-headed, unfair, or even draconian. And there's some references to Babcock versus Canada, Attorney General, 2002, 3S. So that's 2003, and then Supreme Court ruling in paragraph at 3 at paragraph 57. Point 16. The only proviso, and it is an important one, is that any such legislation must comply with the Charter, in brackets, and arguably any applicable unwritten constitutional norms and principles, close bracket. As long as the statute is, quote, neither ultra vires nor contrary to the Charter, courts have no rule to supervise the exercise of legislative power, end of quote. Reference to Canada Assistance Plan, BC, brackets 1991, the number 2, SCR 525 at paragraph 85. The remedy for bad laws that are otherwise intra vires and charter compliant is the ballot box, not judicial review. That reference is British Columbia versus Imperial Tobacco, Canada, 2005. Supreme Court ruling at 473 at paragraph 66. It also says, also see East York versus Ontario, the Attorney General, 1997. Ontario Justice number 4100 at paragraph 12. And it quotes, courts can, and courts was an additional word, courts can only provide remedies for the public grievances if those grievances violate legal as opposed to political proprieties. What is politically controversial is not necessarily constitutionally impermissible. End of quote. Point 17. Second, a federal or provincial legislature is sovereign and cannot bind itself. The provincial legislature can overrule or contradict a previously enacted law. A subsequent enactment that is inconsistent with an earlier enactment is deemed to impliedly repeal the earlier enactment to the extent of the inconsistency. There's a reference to that at 6, case Sullivan. Sullivan on the Construction of Statutes, 6th edition at paragraph 11.64. Thus, the argument that the City of Toronto Act, there's a reference for that, so S.O. 2006, citation 11, Schedule A, sections 6, bracket 1, close bracket, and 2, so that's bracket 2. So that would be 6, 1, and 2. Also see Section 6 of the Toronto-Ontario Cooperation and Consultation Agreement, which provides that Ontario shall consult with the city on, among other things, quotes, any proposed change in legislature or regulation that, in Ontario's opinion, will have a significant impact on the city. End of quote. However, Section 14 of the same agreement provides that a failure to abide by any of its terms does not give rise to any legal remedy. And the rest of point 17 says, thus, the argument that the City of Toronto Act somehow imposed on immutable obligation to consult cannot succeed. The province was entitled to enact Bill 5 and ignore completely the promise to consult that was set out in the previous law. Page 6. Point 18. Third, speaking broadly and again absent a constitutional issue, the provincial legislature has no obligation to consult and no obligation of procedural fairness. There's a reference. The reference is the obligation of procedural fairness materializes at the level of subordinate legislation in the judicial review of an administrative actions of agencies and tribunals, not at the level of primary legislation, such as Bill 5 herein. The doctrine of legitimate expectations as aspect of procedural fairness does not apply to legislative enactments. There's a reference. So the reference is Old St. Boniface Residence Association Incorporated versus Winnipeg. So that's the city of Winnipeg, 1990. Supreme Court ruling or Regina, 1170 at paragraph 74. There's also Canada, that's the AG, versus MAVI, M-A-V-I, so that's M as in Mary, A, V as in Victory, I, 2011. It says 2 SCR 504 at paragraphs 44, 68, 67. Sorry, it says 68 to 69. So paragraphs 44, paragraph 68, to paragraph 69. And also reference read Canada Assistance Plan, Supra Note 4 at paragraphs 58 to 61. Now I got confused as to where I was reading from. Let's see, point 9 was the reference, right. So we're now at point 19. At first glance, Bill 5, although controversial in content, appears to fall squarely within the province's legislative competence. Upon closer examination of the surrounding circumstances, however, one discovers at least two constitutional deficiencies that cannot be justified in a free and democratic society. The first relates to the timing of the law and its impact on candidates. The second to its content and its impact on voters. Point 20. As I explain in more detail below, the Impungned Provisions breach Section 2B of the Charter in two ways. 1, or I, as referenced here, because the bill was enacted in the middle of an ongoing election campaign, it breached the municipal candidate's freedom of expression, and 2, because Bill 5 almost doubled the population size of city wards from an average of 61,000 to an average of 111,000, it breached the municipal voters' right to cast a vote that can result in effective representation. Point 21. Either breach by itself is sufficient to support a court order declaring that the Impungned Provisions are of no force or effect. Heading 1. Breach of the candidate's freedom of expression. Point 22. Section 2B of the Charter guarantees freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Although set out in the Charter, the Supreme Court has made clear that freedom of expression did not originate in the Charter, but was entrenched in the Constitution in 1982 as, quote, one of the most fundamental values of our society, close quote. And there's a reference, the court case, Libman versus Quebec. So that's L-I, B as in Bob, M as in Mary, A, N as in Nancy, versus Quebec. The Attorney General, 1997, 3 SCR, and then the numbers 569 at paragraph 28. Page 7, point 23. The Supreme Court has frequently and consistently held that freedom of expression is of crucial importance in a democratic society. There's a reference, quoting Ibid. All the more so when freedom of expression is engaged in the political realm. Political expression is at the very heart of the values sought to be protected by the freedom of expression guaranteed by Section 2B of the Charter. Here is how the court put it in Keekstra. So there's a reference early to Keekstra, which is R versus Keekstra, 1990. So that's under 3 SCR 697 at paragraph 763 to 64. Here is how the court put it in Keekstra. The connection between freedom of expression and the political process is perhaps the linchpin of the Section 2B guarantee, and the nature of this connection is largely derived from the Canadian commitment to democracy. Freedom of expression is a crucial aspect of the democratic commitment, not merely because it permits the best policies to be chosen from among a wide array of proffered options, but additionally because it helps to ensure that participation in the political process is open to all persons. And there's a reference to 13, which is again Keekstra, so we've already said that. Point 24. Line 24. The Supreme Court has encouraged a broad interpretation of freedom of expression that extends the guarantee to as many expressive activities as possible. The court has made clear that any activity or communication that conveys or attempts to convey meaning and does not involve violence is covered by the guarantee in Section 2B of the Charter. So the reference is Libman again, noted at 10 at paragraph 29. Line 25. It follows from this that the freedom of expression guarantee extends not only to candidates, but to every participant in a political election campaign, including volunteers, financial supporters, and voters. Reference is Harper versus Canada, the Attorney General, 2004, Supreme Court of Canada, Decision 33 at paragraph 15 and 20. Also, Vancouver Sun, 2004, Supreme Court of Canada, Decision 43 at paragraph 26, and Taman, so that's T-A, M as in Mary, A, N as in Nancy, versus Canada, the Attorney General, 2015, Federal Court 1155 at paragraph 41. Point 24. The Supreme Court has encouraged a broad interpretation of freedom of expression that extends the guarantee to as many expressive activities as possible. The court has made clear that any activity or communication that conveys or attempts to convey meaning and does not involve violence is covered by the guarantee in Section 2B of the Charter. Point 25. It follows from this that the freedom of expression guarantee extends not only to the candidates but to every participant in a political election campaign, including volunteers, financial supporters, and voters. Each of them would have a genuine Section 2B issue with Bill 5. However, for ease of understanding, I will focus only on the candidates. Point 26. In a Section 2B claim, the court asks two questions. First, whether the activity in the question falls within the scope of freedom of expression, and secondly, whether the purpose of effect of the legislation is to interfere with that expression. The reference is Irwin Toy Limited versus Quebec, Attorney General, 1989. 1 SCR 927 at 978. Page 8, line 27. The expressive activity of candidates competing in the city's ongoing election obviously falls within the scope of Section 2B. The more pertinent question is whether their freedom of expression has been infringed by the enactment of Bill 5. That is, whether the enactment of Bill 5 changing the electoral districts in the middle of the city's election campaign substantially interfered with a candidate's right to freedom of expression. There's a reference at and the reference is the case law is clear that the Charter cannot be subdivided into two kinds of guarantees, freedoms and rights. The freedom to do a thing, when guaranteed by the Constitution and interpreted purposefully, implies a right to do it. Hence, I say the right to freedom of expression. See Ontario Attorney General versus Fraser, 2011, and it's 2 SCR 3 at paragraph 67. Point 28. Perhaps the better question is, how could it not? Point 29. The evidence is that the candidates began the election campaign on or about May 1st, 2018 on the basis of a 47-ward structure and on the reasonable assumption that the 47-ward structure would not be changed midstream. The 47-ward structure informed their decision about where to run, what to say, how to raise money, and how to publicize their views. When Bill 5 took effect on August 14th, midway through the election campaign, most of the candidates had already produced campaign materials such as websites and pamphlets that were expressly tied to the ward in which they were running. A great deal of the candidates' time and money had been invested within the boundaries of a particular ward when the ward numbers and sizes were suddenly changed. Point 30. Bill 5 radically altered the city's electoral districts, in most cases doubling both their physical size and the number of potential voters. The immediate impact of Bill 5 was widespread confusion and uncertainty. There was confusion about where to run, how to best refashion one's political message and reorganize one's campaign, how to attract additional financial support, and what to do about all the wasted campaign literature and other material. There was uncertainty flowing from the court challenge, the possibility that the court challenge might succeed, and the consequences for all concerned if this were to happen. 31. The evidence is that the candidate spent more time on doorsteps addressing the confusing state of affairs with potential voters than discussing relevant political issues. The candidates' efforts to convey their political message about the issue in their particular ward were severely frustrated and disrupted. Some candidates persevered, others dropped out of the race entirely. Page 9, line 32. There can be no doubt on the evidence before the court that Bill 5 substantially interfered with a candidate's ability to effectively communicate his or her political message to the relevant voters. Point 31. This is not a situation where provincial law changing the number and size of the city's electoral districts was enacted, say, 6 months before the start of the city's election period. Had this happened, the law would not have interfered with any candidate's freedom of expression, and no candidate could have alleged otherwise. The province is right to say that Section 2B of the Charter does not guarantee a 47-ward election platform. Line 34. Here, the law changing the city's electoral districts was enacted in the middle of the city's election. This midstream legislative intervention not only interfered with the candidate's freedom of expression, it undermined an otherwise fair and equitable election process. Point 35. Electoral fairness is a fundamental value of democracy. The reference is in Figueira versus Canada Attorney General, 2003, Supreme Court of Canada, Decision 37, at paragraph 50. As the court noted in Libman, the principle of electoral fairness flows directly from a principle entrenched in the Constitution, the political equality of citizens. Elections are fair and equitable only if the candidates are given a reasonable opportunity to present their positions. 36. Here, as already noted, because Bill 5 took effect in the middle of the city's election, candidates were not given a reasonable opportunity to present their positions. The enactment and imposition of Bill 5 radically redrawing the electoral districts in the middle of the electoral process undermined the very notion of a fair and equitable election. Point 37. Once the province has entered the field and provided an electoral process, it may not suddenly and in the middle of this electoral process impose new rules that undermine an otherwise fair election and substantially interfere with the candidate's freedom of expression. Indeed, as the Supreme Court's decision in Libman makes clear, where a democratic platform is provided, in that case a referendum, here a 47-ward election structure, and the election has begun, expressive activity in connection with that platform is protected against legislative interference under the traditional Irwin-Toy analysis, which focuses on substantial interference. Page 10. Line 38. I have no difficulty finding on the evidence before me that the enactment of Bill 5, changing the number and size of the electoral districts in the middle of the election campaign, substantially interfered with the candidate's freedom of expression. A breach of the municipal candidate's right to freedom of expression under Section 2B of the Charter has been established. Point 39. I now turn to the municipal voter's right under the same provision of the Charter. Heading 2. Breach of the municipal voter's right to freedom of expression. Point 40. I begin with 3 propositions that are not in dispute. First, the most fundamental of our rights in a democratic society is the right to vote. That references Provincial Electoral Boundaries, Saskatchewan, 1991. And that's 2 SCR 158 at paragraph 1. Absent a right to vote, democracy cannot exist. That references Hague versus Canada, Chief Electoral Officer, 1993, 2 SCR 995 at paragraph 104. Second, voting is an expressive activity. Indeed, the most important expressive activity. The reference is referenced above. So that's Hague versus Canada at paragraph 158, and is fully protected under Section 2B of the Charter. Third, the right to vote is in essence the right to effective representation and not just voter parity. Point 41. As the Supreme Court concluded in the Saskatchewan reference, The purpose of the right to vote enshrined in Section 3 of the Charter is not equality of voting power per se, but the right to effective representation. Ours is a representative democracy. Each citizen is entitled to be representative in government. Representation comprehends the idea of having a voice in the deliberations of government, as well as the idea of the right to bring one's grievances and concerns to the attention of one's government representative. Elected representatives function in two roles, legislative and what has been termed the ombudsman role. Or termed, by the way. Page 11.42. City councilors obviously function in both roles, legislative and ombudsman. In the former role when debating and passing bylaws or other resolutions, and in the latter role when handling the myriad of constituents' grievances and concerns that find their way to their desks. Point 43. The important legal issue is whether the comments by the Supreme Court about effective representation made in the context of Section 3 of the Charter, which guarantees every citizen's right to vote in a federal or provincial election, but not a municipal election, can also apply to the context of a municipal election. Can the concept of effective representation inform this court's analysis of the municipal voter's right under Section 2B of the Charter? Point 44. In my view, it can, for the following reasons. Line 45. The concept of effective representation is not rooted in Section 3 of the Charter. Its origins can be tracked back to Canada's founding fathers and the early debates about the appropriate design of electoral districts. As the Supreme Court explained in Saskatchewan reference, parity of voting power, though of prime importance, is not the only factor to be taken into account in ensuring effective representation. Sir John A. Macdonald, in introducing the Act to readjust the representation in the House of Commons, SC 1872, C13, recognized this fundamental fact. House of Commons Debates, Volume 3, 4th Session, paragraph 926, June 1st, 1872. It will be found that while the principle of population was considered to be a very great extent, other considerations were also held to have weight, so that different interests, classes, and localities should be fairly represented, that the principle of numbers should not be the only one. Sorry, I just got a little bit dramatic there. I don't know why I used that voice tone, but anyway. Line 46. Even if the concept of effective representation is found to have its origins in Section 3 of the Charter, there is no principled reason why, in an appropriate case, the effective representation value cannot inform other related Charter provisions, such as the voter's right to freedom of expression under Section 2B. The Charter of Rights is not comprised of watertight compartments. As the Supreme Court noted in Bayer versus Alberta, so that's 2007 decision, 2 SCR 673. Charter rights overlap and cannot be pigeonholed. And as this court noted in Dijon, the rights enshrined in Section 3 have a close relationship to freedom of expression and to the communication of ideas. There is an affinity between Sections 3 and 2B, freedom of expression of the Charter. Page 12 of Justice Belobaba's decision. Line 47. If voting is indeed one of the most important expressive activities in a free and democratic society, then it follows that any judicial analysis of its scope and content under the freedom of expression guarantee should acknowledge and accommodate voting's core purpose, namely effective representation. That is, the voter's freedom of expression must include her right to cast a vote that can result in meaningful and effective representation. Line 47. The following caution from the Supreme Court in Hague has direct application on the facts herein. While Section 2B of the Charter does not include any right to any particular means of expression where a government chooses to provide one, it must do so in a fashion that is consistent with the Constitution. Line 49. In other words, even though Section 2B does not guarantee a right to vote in municipal elections, if such an expressive right has been provided by the provincial government, then the right so provided must be consistent with and not in breach of the Constitution. Line 50. Here, the province is statutorily provided for a resident's right to vote in municipal elections, including the upcoming election in the City of Toronto. This right, having been provided, must be provided in the fashion that is consistent with the Constitution. And where it is not, a municipal voter is entitled to allege constitutional infringement, including an infringement of Section 2B based on the denial of her right to cast a vote that can result in effective representation. Page 13. Line 51. A finding that Bill 5 has infringed the municipal voter's freedom of expression by abridging her right to cast a vote that can result in effective representation does not constitutionalize a third level of government, nor does it constitutionalize a right to vote at the municipal level. The finding of charter infringement flows from the application of the Supreme Court's caution in Hague. So that's the Hague decision that was referred to earlier. To the facts of this case, once provided, a right to vote in a municipal, I think it might have wanted to say municipal election, must comply with the charter and in particular Section 2B. Line 52. This very approach was taken by the Court of Appeal in the megacity amalgamation case. The amalgamation legislation was challenged on the ground that the resulting voter-councillor ratios were too high and denied meaningful access to one's elected representative. The applicant's challenge was based in part on Section 2B of the Section 2B of the Charter. The Court of Appeal noted that it was mindful of the caution in Hague and proceeded to consider the Section 2B argument. The Court of Appeal found no breach of Section 2B because in that case there was no suggestion of any curtailment of the right to vote, and no evidence that the size of the electoral districts post-amalgamation infringed the concept of effective representation. Line 55. Here, however, the applicants before this court allege a clear curtailment of the right to vote and have filed extensive evidence about effective representation. I refer, of course, to the findings and conclusions of the Toronto Ward Boundary Review. Line 54. And he's called that TWBR, so the Toronto Ward Bound Review. The TWBR began in 2013 and concluded in 2017. Over the course of the almost 4-year review, the TWBR conducted research, held public hearings, and consulted widely. The TWBR considered the effective representation requirement and the ward size that would best accomplish this objective. The option of reducing and designing the number of wards to mirror the 25 federal election districts was squarely addressed and rejected by the TWBR. City Council's decision in 2017 to increase the number of wards from 44 to 47 was directly based on the findings and conclusions of the Toronto Ward Boundary Review, which in turn were affirmed on appeal to the Ontario Municipal Board and the Divisional Court. There is a case reference. It's with the exception of a minor change in one ward boundary, leave to appeal the decision of the OMB, now known as the Local Planning Appeal Tribunal, in DiCiano, so that's Councillor DiCiano, versus Toronto, so that's the city, 2017, can be found on Candley 85757. It says ON, and then it says, so ON being Ontario, and then L, P as in Paul, A as in Apple, T as in Tom, was denied by the Divisional Court. Natali versus City of Toronto, 2018, ONSC 1475 was also included as a reference. This right, let me see, where was I? Sorry, I've gotten lost here. Let me just find my place. Right, so now I'm starting at line 55 on page 14. Put simply, the 25 FEDs option was considered by the Toronto Ward Boundary Review, so TWBR, and rejected because at the current 61,000 average ward size, city councillors were already having difficulty providing effective representation. Line 56. Local council is the level of government that is closest to its residents. It is the level of government that most affects them on a daily basis. City councilors receive and respond to literally thousands of individual complaints on an annual basis across a wide range of topics, from public transit, high-rise developments, and policing to neighborhood zoning issues, building permits, and speed bumps. Line 57. Recall what the Supreme Court said in Saskatchewan in reference about how effective representation includes the right to bring one's grievances and concerns to the attention of one's government representative. This right must obviously be a meaningful right. This is particularly relevant in the context of the councillor's role in a megacity like Toronto. Line 58. The evidence before this court supports the conclusion that if the 25 FEDs option was adopted, city councillors would not have the capacity to respond in a timely fashion to the grievances and concerns of their constituents. Professor Davidson, who filed an affidavit in this proceeding and also participated in the TWBR as a consultant, provided the following expert evidence. It is the unique role of municipal councillors and distinguishes municipal wards from provincial and federal ridings. Boundaries that create electoral districts of 110,000 may be appropriate for higher orders of government, but because councillors have a more involved legislative role, interact more intimately with their constituents, and are more involved in resolving local issues, municipal wards of such a large size would impede individual councillors' capacity to represent their constituents. Page 15. It is my professional opinion, and this is still the reference of Professor Davidson. It is my professional opinion that the unique role of councillors as well as the public feedback received by the TWBR in comparison with ward size in other municipalities demonstrates that a ward size of approximately 61,000 people provides councillors with capacity to provide their constituents with effective representation, and that ward size of approximately 110,000 do not. Line 59. On the basis of the evidence before me, I find that the impungned provisions that impose a 25-ward structure with an average population size of 110,000 infringe on municipal voters' rights under Section 2B of the Charter to cast a vote that can result in meaningful and effective representation. Once the province has provided for a right to vote in a municipal election, that right must comply with the Charter. Line 60. In sum, I have found two distinct breaches of Section 2B. The first, that the impungned provision substantially interfered with the candidate's right to freedom of expression when it changed the city's electoral districts in the middle of the election campaign. The second, that the impungned provision substantially interfered with the voter's right to freedom of expression when it doubled the ward population size from a 61,000 average to a 111,000 average, effectively denying the voter's right to cast a vote that can result in effective representation. Line 61. I further find for the reasons that follow that neither of these breaches can be justified or saved under Section 1 of the Charter. Heading: Breaches of Section 2B not saved under Section 1. Line 62. Section 1 of the Charter provides that the rights and freedoms guaranteed therein are subject to, quote, such reasonable limits as can be demonstrably justified in a free and democratic society, end of quote. Line 63. The analytic approach that a court must take under Section 1 has been repeated and refined in numerous Supreme Court decisions since it was first set out in Oakes. Here is the prevailing articulation. The court must first ask whether the objective the statutory restrictions seek to promote response to pressing and substantial concerns in a democratic society, and then determine whether the means chosen by the government are proportional to that objective. The proportionality test involves 3 steps. The restrictive measures chosen must be rationally connected to the objective. They must constitute a minimal impairment of the violated right or freedom, and there must be proportionality both between the objective and the deleterious effects of the statutory restrictions, and between the deleterious and salutary effects of those restrictions. Wow, quite the mouthful. Line 64, page 16. The onus of justification under Section 1 is on the government. The standard of proof is the civil standard, namely proof on a balance of probabilities. Normally, the defending government files extensive evidence attempting to provide a justification for the breach under Section 1 of the Charter. Here, either because of time constraints or because there was little in the way of supporting evidence, the province only filed one news release and some excerpts from Hansard, setting out what was said by the Premier and others when Bill 5 was debated in the legislature. Line 65. The news release that was issued by the Premier's office on July 27, 2018, provided 2 rationales for Bill 5. Improved efficiency and overall cost savings. The Premier observed that Toronto City Council has become increasingly dysfunctional and inefficient through a combination of entrenched incumbency and established special interests, and that Bill 5 would create an effective municipal government that saves taxpayers money. Line 66. On August 2nd, 2018, at the second reading of Bill 5, the Minister of Municipal Affairs and Housing set out 3 objectives for the legislation. First, they, in brackets, councillors in support of a 25-ward model, close brackets, agreed that a smaller council will lead to better decision-making at Toronto City Hall, which would benefit Torontonians as a whole. They gave an example of the current 44-member council having 10-hour debates on issues that would end with the most majority of councillors voting the same as they would have at the beginning of the debate. Second, they point out that it will save money. Third, it would result in a fair vote for residents, which was the very reason Toronto itself undertook a review of its ward boundaries. The Toronto councillors I referred to earlier reminded everyone that the Supreme Court of Canada said that voter parity is a prime condition of the effective representation. They gave examples of the current ward system, where there are more than 80,000 residents in one ward and 35,000 in another. They acknowledged that this voter disparity is the result of self-interest, and that the federal and provincial electoral district process is better because it is an independent process which should apply to Toronto as well. The wards we are proposing are arrived at through an independent process. Page 17, line 67. It is important to note that in the debate that followed, the Premier and the MPPs who spoke in support focused on 2 rationales for Bill 5, improved efficiency and cost savings, and did not refer to voter parity. The Premier added some anecdotal evidence from his days as a city councillor. And here's a reference. I can tell you that I was there numerous times for a 10-hour debate on getting Mrs. Jones' cat out of the tree. We would sit there and debate about anything for 10 hours. After 10 hours and thousands of pieces of paper going around, nothing got done. Nothing got done. And guess what? At the end of 10 hours, we all agreed to get Mrs. Jones' cat out of the tree. That's a waste of time. That is why it is time to reduce the size and cost of municipal government. Line 68. During the debate on second reading, the MPPs who spoke in support of Bill 5 focused on 2 objectives: improved efficiency and saving taxpayers money. Other than the brief reference by the minister in the excerpt set out above, nothing more was said about voter parity. The province has indicated to the court that it does not rely on the cost-saving objective for the Section 1 analysis. This leaves 2 objectives: improved efficiency better decision making, a more streamlined city council, those are in brackets, and voter parity, brackets, barely mentioned. Line 69, the Supreme Court noted in health services, so that's the case of Health Services and Support Facilities Subsector Bargaining Association versus British Columbia, 2007, Supreme Court of Canada, Decision 27. So in that case, it says I'll read it again. During the debate on the second reading, the MPP spoke in support of Bill 5. And, going down to line 69. We already said the above. The Supreme Court noted in health services that it can be useful, and so that's a case, that it can be useful in the context of the Section 1 analysis to ask whether the government considered other options or engaged in consultation with the affected parties before enacting the challenged legislation. Legislators are not bound to consult with affected parties before passing legislation. On the other hand, it may be useful to consider in the course of the Section 1 justification analysis whether the government considered other options or engaged in consultation with the affected parties in choosing to adopt its preferred approach. The court has looked at pre-legislative conditions in the past in the court of minimal impairment. This simply evidence, I think it might have meant the simple evidence going to whether other options in a range of possible options were explored. Page 18, only 3 more pages to go. Line 770, so that's line 70. Here, there is no evidence that any other options or approaches were considered or that any consultation ever took place. It appears that Bill 5 was hurriedly enacted to take effect in the middle of the city's election without much thought at all, more out of pique than principle. 71. In any event, the constitutional problem here is twofold. There is no evidence other than anecdotal evidence that a 47-seat city council is in fact dysfunctional, or that more effective representation can be achieved by moving from a 47-ward to a 25-ward structure. And 2, even if there was such evidence, there is no evidence of any urgency that required Bill 5 to take effect in the middle of the city's election. Line 71. In any event, the constitutional problem here is twofolded. I think I've just read that. Sorry, it's line 72 now. Because remember, it said take effect in the middle of the city's election, which is quite the thing. Line 72. In my view, the province's justification of the impungned provisions in Bill 5 fails at... hold on 1 second. Sorry, I just need to pause. Thank you for your patience. I just needed a little bit of a drink of water. Line 72. In my view, the province's justification of the impugned provisions in Bill 5 fails at this first step of the Section 1 analysis. There is simply no evidence that the two objectives in the question were so pressing and substantial that Bill 5 had to take effect in the middle of the city's election. Line 73. The Supreme Court has stated time and time again that preserving the integrity of the election process is a pressing and substantial concern in a free and democratic society. Passing a law that changes the city's electoral districts in the middle of its election and undermines the overall fairness of the election is antithetical to the core principles of our democracy. Line 74. Even if the province could establish that the two rationales that were provided to explain Bill 5 were so pressing and substantial as to justify its enactment in the middle of the city's election, the province could not establish proportionality, and in particular, minimal impairment. As the Supreme Court noted in RJR-McDonald, so that's the case of RJR McDonald Incorporated versus Canada, the Attorney General, 1995, 3SCR 199. Passing a law that changes the city's electoral districts in the middle of its election and undermines the overall fairness of the election is... Oh, I already read that part. Sorry, getting a little confused here. Let's go back to line 74, which is where it was referencing R.J.R. MacDonald. Even if the province could establish that the two rationales that were provided to explain Bill 5 were so pressing and substantial as to justify its enactment in the middle of an election, the province could not establish proportionality and in particular minimal impairment. As the Supreme Court noted in R.J.R. MacDonald, quote, if the government fails to explain why a significantly less intrusive and equally effective measure was not chosen, the law may fail, end of quote. Line 75. Dealing with the first objective, improved efficiency in city council debates, the province has not shown why a significantly less intrusive and equally effective measure was not chosen. Such, for example, imposing time limits on debate or more to the point, delaying the coming into force of the city council restructuring law until after the city's election. Page 19. Well, I guess it ends there. I didn't quite understand the sentence. Maybe I should read that again because it wasn't fair how I read it for you. My apologies. Line 75. Dealing with the first objective, improved efficiency in city council debates, the province has not shown why a significantly less intrusive and equally effective measure was not chosen. Such, for example, imposing time limits on debate or more to the point, delaying the coming into force of the city council restructuring law until after the city's election. Page 19, line 76. Dealing with the second objective, voter parity, and giving the minister the benefit of the doubt that he understood that the primary concern is not voter parity but effective representation, there is no evidence of minimal impairment. The province's rationale for the moving to a Ward 25 structure had been carefully considered and rejected by the TWBR and by City Council just over a year ago. If there was a concern about the large size of some of the city's wards, by my count, 6 wards had populations ranging from 70,000 to 97,000. Why not deal with these 6 wards specifically? Why impose a solution increasing all ward sizes to 110,000? That is far worse in terms of achieving effective representation than the original problem. And again, why do so in the middle of a city's election? 77. Crickets. So literally the word crickets is there, meaning there's no answer, there's no response. 78. I am therefore obliged to find on the evidence before me that the breaches of Section 2B of the Charter, as found above, cannot be demonstrably justified in a free and democratic society and cannot be saved as reasonable limits under Section 1. Heading, it's too late to return to the 47 structure. And that's a question. Line 79 under that heading. The province's final submission is that it's too late to return to the 47 ward structure. The province points to the city clerk's candid admission at the August 20th, 2018 council meeting that she is not confident that the city could now return to the 47 ward structure. 80. The city clerk may not feel confident about a 47 ward election, but she is not saying that the hurdles are insurmountable. In any event, the city itself is asking explicitly for a return to the 47 ward structure, and it is entitled to do so. I must assume that the city has considered the attendant logistical challenges and has concluded that an October 22nd election based on the 47 ward structure can indeed be achieved in the short time that remains. Heading Conclusions. Line 81. I find that the province's enactment of Bill 5 in the middle of the city's election substantially interfered with the municipal candidate's freedom of expression that is guaranteed under Section 2B of the Charter of Rights. Line 82. I find that the reduction from 47 to 25 in the number of city wards and the corresponding increase in ward size population from an average of about 61,000 to 111,000 substantially interfered with the municipal voters' freedom of expression under Section 2B of the Charter of Rights, and in particular her right to cast a vote that can result in effective representation. Page 20. Line 83. I further find on the evidence filed by the parties that these breaches of Section 2B cannot be demonstrably justified in a free and democratic society and cannot be saved as reasonable limits under Section 1 of the Charter of Rights. Heading Disposition. Line 84. The applications filed by the City of Toronto, Rocco Achapang, Chris Moyes, Ish Adoranmu, and Prabha Kholsa on her own behalf and on behalf of Women Win Toronto, asking this court to set aside the impugned provisions in Bill 5 that purport to reduce the number of wards from 47 to 25 are granted. Line 85. The impugned provisions have no force and effect and are set aside immediately. 86. It follows from this decision that the city's election on October 22, 2018 shall proceed as scheduled, but on the basis of 47 wards and not 25 wards. If the provincial government wishes to enact another Bill 5 type law at some future date to affect future city elections, it may certainly attempt to do so. As things now stand, and until a constitutionally valid provincial law says otherwise, the city has 47 wards. Line 87. I shall remain seized of this matter to receive submissions from council and fashion the appropriate draft order, including any related remedies being sought by the Toronto District School Board with regards to TDSB school board elections and recently enacted provincial regulations. Line 88. If the parties cannot agree on costs, they may forward brief submissions to my attention. The applicants shall file their cost submissions within 21 days and the province within 21 days thereafter. I am very obliged to all council for their cooperation and assistance. The end. Justice Edward P. Belobaba, dated September 10th, 2018. A 20-page decision provided in 21 days of hearing. Pretty awesome. Pretty awesome. Thank you to all. Together, we succeed.